Call to order the meeting of the Michigan Board of State Canvassers. Director Brader is joining us remotely. Director Brader, has the meeting been noticed in accordance with the Open Meetings Act?
Yes, it has. And sorry I can't be with you in person today.
Thank you. Okay, the first order of business is public comment. Do we have anyone who has asked to speak? Mr. Fracassi?
Mr. Gallant has asked to speak, but I'm not sure if he is logged on or not. And I don't know if there are any other cards.
Hello, yes. Yes, you hear me now?
Okay.
There you go.
Mr. Gallant, you have 2 minutes.
Okay, thank you very much. This is James Gallant, Marquette County Suicide Prevention Coalition. These are my opinions. And Madam Chair, I FOIA'd the minutes and the audio tapes of the committee, the process committee meeting that you were talking about last week, the last meeting. You were just talking about it, some more discussion about it. It seemed like you were making decisions at the meeting last week. And it's my prediction that Jonathan Brader probably implemented most of the things that you agreed to at your meeting, at your committee meeting, your process committee meeting. And it's probably already implemented, so you won't have to vote on it ever. And I believe that that committee meeting was followed in the Open Meetings Act, Attorney General opinion number 7,000 from 1998, effectively authorizing the committee to make decisions of what will and will not come back to this board. So that's the decision. You don't make the decision. It's just what will or will not come back to this board for a decision. And your committee did that. So that was under the Open Meetings Act. And that's, I think that Secretary Benson is implementing Marxist principles in this consensus building process that you're undertaking, Madam Chair. In that Democratic Party thing, to where you don't vote, you get circumventing our Constitution, your oath of office, to follow Robert's Rules of Order. There shall be no debate before there's a motion is properly seconded. You know those things. And the decorum is your statements are to be germane to the immediately pending motion. So all of the rules, you're like, it's like you're implementing a private enterprise here. Your own rules, sidebar rules that you and the other members have agreed to on the sidebar. And then fist bumping, and you're going to get it done. And you did get it done, and you made decisions without voting. And this is effectively, the Open Meetings Act requires you to vote to suspend the rules. So that's what you're not doing. You can suspend the rules, just do it. And so it's please have the Attorney General look into this stuff about the Open Meetings Act violations and your processes that your committee that you're creating, that Jonathan is running off and just making the decisions and doing the stuff. It's already implemented. You don't have to make
Mr. Gallant, thank you for your input. Okay, the next item of business is consideration of the meeting minutes for the July 17th, 2023 meeting. The minutes have been circulated. Do we have a motion?
I motion to approve the meeting minutes from the July 17th, 2023 meeting.
Even though I was absent from that meeting, I will support.
All in favor? Aye. Okay, the motion carries. The next item is consideration of the sufficiency of the recall petition submitted by Sebastian Palomara against, is it Jaime or Jamie? Jamie Churches. Mark Brewer has asked to speak to this matter. Mark?
No.
Both? Okay.
Mark, I will note that you have asked to speak to items 3 through 6 and 8 and 9, and you are the only person who has asked to speak to us today, so we're not going to quibble about time.
Madam Chair, may I just ask a question just for clarification? So none of the sponsors of any of these petitions are present?
I don't know if they're present, but no one has filed notice that they wish to speak.
Thank you, Madam Chair. My name is Mark Brewer. I'm a lawyer with the law firm of Goodman Acker, and I represent here today not only State Representative Jamie Churches, but the other 5 Democratic state representatives who are subject to so-called recall petitions. The board should reject the petition against Representative Churches as well as the other ones for the reasons that I'm going to indicate and as we laid out in our written response filed with the Bureau and the board last Friday. First of all, the board, as a threshold matter, can't actually review these so-called petitions that are before it this morning because the form is defective. And let me lay out why that is. The governing statute here, MCL 168.951A, only allows the board to review a petition. And it's very clear about that. The language is very clear, and that's a mandatory requirement under longstanding Michigan case law that we cited in our letter. And MCL 168.951A lays out several mandatory requirements for a petition. It has to comply with section 544C sub 1 and 2. It has to be printed. It has to state factually and clearly each reason for the recall. It has to contain a certificate of a circulator and the form prescribed by the Secretary of State. In addition to 951A, the Campaign Finance Act clearly requires a disclaimer be placed upon any recall petition in this state. This petition fails to meet these standards, and therefore you don't even need to get to the issue of factuality and clarity this morning. You should tell all of these petitioners to go bring you a proper petition so that you can do your job. Let me go through the defects. First of all, on none of these petitions is there a disclaimer. Only a label from the printing company, which apparently produced this form. And a disclaimer is particularly important here. Not only is it required by the Campaign Finance Act, but it's particularly important here. On every one of these petitions, the handwriting of the so-called sponsor, and I use that in quotes, the sponsor doesn't match the handwriting of the reasons stated, which would lead one to believe that, in fact, the person who allegedly signed a sponsor didn't write this petition. And then if you further compare the handwriting on all 6 petitions and look at the reasons stated, that handwriting does match, leading, again, one to believe that, in fact, there's one person who wrote all of these petitions and then went out and tried to recruit people to be sponsors of a petition they did not write and are not the author of. So it appears that all 6 of these petitions were ghostwritten by a single person. We believe a gentleman named Frank Tarnowski, who has told the Bureau that he's the contact person for at least 4 of the 6 petitions. He, in fact, we believe, is the real sponsor of these petitions. These other people are fake sponsors, and this board has had a lot of experience dealing with fakes over the last year and a half. They were recruited by Tarnowski to be the front people when, in fact, he is the sponsor. Signers have a right to know by statute and in general, under principles of transparency, who the real sponsor of these petitions are. And that's the important purpose of a disclaimer. And that disclaimer is missing here again on all 6. Signers of recall petitions in this state should not be misled by a ghost-written petition with a fake sponsor. And that is the situation with all 6 of these petitions. Beyond that, since Mr. Tarnowski is the real sponsor and he lives in Wyandotte, 5 of the 6 petitions before you were not submitted by a resident of the district, which is also a legal requirement as we laid out in our papers filed last Friday. So 5 of the 6 petitions would fail because the sponsors are not residents of the districts in which they seek the recall. And finally, the statute also requires that the petition be printed. The only exception in the statute, and it's very clear there, is that the reasons for the recall can be typed. On all 6 of these petitions, the reasons are handwritten, and therefore they are not a proper petition under the statute. And it's obviously a very important reason for why the reasons have to be typed or printed. If you have handwritten reasons, they can be changed, right? They can be erased. They can be altered after this board goes through the process of reviewing for clarity and factuality. I'm not asking you to approve or say that you have the power to approve the form of the petition. You don't. But the statute is very clear that as a precondition of this board even reviewing factuality and clarity, there has to be a proper petition before you. And none of these petitions are proper. They do not meet the definition of petition under the statute. So I think that I ask, and I think the board should reject all these petitions, tell whoever the sponsors are to go back and bring you a proper petition for you to review as to clarity and factuality. Beyond that, on each of these petitions, the reason for the recall is not clear. Each of these petitions refers only to a bill number. There is absolutely no explanation of its content. And the natural question of a signer would be, well, what does this bill do? What does it contain? But there is no indication of that, and so it's unclear for that reason. This board's guidance, its published guidance on recall petitions, gives several examples of petition language that it has approved or disapproved in the past. And there's a very specific guidance on legislation. And in that guidance, it says you should have a brief description of what the legislation is. And again, we cite this example in our written responses. But it's not just this board's guidance that governs here. The Donegan case, which we cited in our papers as well, in which the Michigan Court of Appeals reviewed a petition which sought recall based on legislative action. The court there approved a statement of reasons which gave a brief description of what the legislation did. The court said it was not necessary to go into great detail, but that there had to be some description, a brief description of what the legislation was. And then finally, there's a very important statute here, which is relevant as well. And one of the statutory provisions says that a piece of legislation, if it is the subject of a recall petition, cannot be misrepresented by the petition. There would be no need for that statutory provision if a description was not required, right? That provision clearly anticipates that the petition will have a description of the legislation and then firmly directs that there be no misrepresentation. So that's yet another reason why, in this circumstance, for all these reasons, these petitions are defective. They are not clear. There must be a brief description of the legislation at issue. Now, let me just deal quickly with a prior case, which we mentioned in terms of full disclosure in our papers. And that is the Whitmer case. This board dealt with a lot of recall petitions against the governor last cycle. That case does not stop the board from requiring a description of this legislation for several reasons. First of all, the court did not overturn the Donegan decision that I referenced a moment ago, in which the Court of Appeals upheld a brief description of legislation as being sufficiently clear. In Whitmer, the court only held that a lot of detail was not required. Again, it didn't question Donegan, it didn't overrule Donegan, it treated Donegan as settled law. But I think also importantly, the Whitmer case involved executive orders, did not involve legislation. And the statutory requirement that I just mentioned to you about not misrepresenting legislation was not applicable in that case. And the court so held. The court said, look, we're not going to consider the effect of this requirement that you not misrepresent legislation because we're not dealing with a recall petition on legislation. We are dealing with a recall petition that deals with executive orders. So for all those reasons, the Whitmer case need not and should not stop this board from requiring these sponsors to add some clarity to these petitions by describing the legislation at issue. With all that, Madam Chair, I'd be glad to take questions about either Representative Church's petition or any of the others.
Thank you, Mr. Brewer. Questions?
No.
Any questions? Mr. Brewer, you said that you were not asking us to approve the form of the petition, but you are suggesting that the form is deficient and therefore we shouldn't consider it. So I'm a little puzzled by the distinction that you're making.
So we said in our papers, I used the word precondition, that a proper petition is a precondition of this board looking at clarity and factuality. If I was in court, I would say the board has no jurisdiction to examine the factuality and clarity because these petitions don't meet the definition of petition. And that's the only thing this board can look at. I mean, literally, the way this process is now going with these sloppy petitions you have over this morning, I could come to the Bureau with a blank piece of paper and write some reasons down, and that would be submitted to you to review for clarity and factuality. At some point, we need to enforce the standards in the statute and require sponsors to have disclaimers to type or print, as the statute requires, their petitions before this board even gets into the matter of factuality and clarity. So, Madam Chair, it's a matter of, again, jurisdiction and precondition. If and when these sponsors show up with a petition in the proper form, you won't have jurisdiction to review that, but they've got to meet these threshold determinations.
Adam, question, has there never been a petition put through here that's been approved, that's been handwritten on the petition application?
So we have in the nominating petition context, I'm actually even going to back up. So correct me if I say anything wrong as well, Heather. So the form elements of it, there's no approval as to form process like there is for initiatives for recall petitions. As you are aware, with initiatives, statewide drives, there's a pretty extensive approval as to form review that the Bureau of Elections does, presents it to the Board of State Canvassers, that whole process. There's nothing equivalent with recall petitions like we have for that. There is a statute, and I'll probably kick it to Heather if Heather's okay with that now, that talks about form requirements. It's 961 that says that the filing official, so in this case the Secretary of State for these offices, the filing official, when the petition is filed, shall examine the recall petition and determine whether it is in proper form and determine whether or not there's a sufficient number of signatures. So how I read that is that the form questions would come at the same time as when the filing official is determining whether or not the signatures are sufficient. I hope that makes sense, how I explained it. And I would obviously defer to Heather if I said anything incorrectly. Okay.
If I may, Mr. Hauskamp, that's absolutely correct. But that's at the back end of the process. We're under MCL 168.951A, which is at the front end of the process. And it says a petition for recall of an officer listed in section 959, these state representatives, must meet all of the following requirements. That's a front end requirement before the petition can even get to this board, and certainly before it's circulated. Undoubtedly, Mr. Fracassi is correct. And there could be challenges down the road, but now is the proper time also to raise these questions of defects of the form and tell these petitioners to get it right.
Again, you know, I said before in our conversations, I'm not an attorney. When I read the word printed, I see that some of these are in fact printed, all being printed by hand, as opposed to printed by a printer or a typewriter. Is there a legal definition of the term printed?
Well, truly, most of the petition is printed. That's correct. And subsection B of 951A says it must be printed. But then if you go down to C, it says the reason for recall may be typewritten. So the only exception to being printed is the reason for recall, and the only allowance there is typewritten. These are handwritten.
Did you say may?
May be typewritten. So
So they can do it, they don't have to.
They don't have to, that's right. But if they don't typewrite it, it has to be printed because of B. B says the entire petition must be printed, the entire thing.
So in order to recall an official, you have to own a typewriter.
Or go to a printer, which is what you do anyway. I mean, clearly these were printed, and but again, I think we need to, remember the purpose of barring handwriting. It's so they're not altered during the course of the recall. Once you all approve the clarity and factuality, these should not be altered as they are circulated. And if you allow handwritten reasons, that's exactly the kind of Pandora's box that's being opened up. So I think the statute anticipated that.
Your premise being that they would copy exactly what's here
They could,
and
but they
use that.
also could not, right? If it's not printed or typed, you can alter the handwriting and handwrite other reasons.
But if they did that and turned that in, it would not be what they'd been approved for. And the language at the top, there's you or somebody or whoever's on the other side would find that out and reject those at the end. So I'm not sure for me, the issue here is the disclaimer and whether or not the disclaimers on here are improper or match things we have provided for in the past. If not, then I see no reason to move forward, aside from rejecting them.
My questions are not directed to Mr. Brewer. That's why I haven't asked any yet.
Okay.
Mine are more towards staff, towards our representatives from the AG office, because having been the person who has sat here the longest, we have, as a board, moved to clarify our own actions here. So there, when we first started off doing recall petitions, I know that we were asked by the court to change what we've been doing. And so my question is not to Mr. Brewer, but obviously to Heather or Eric. Have we ever put in, and I think it ties into Tony's question, campaign finance law into when we're talking about recalls? I think I'm right, Tony? Yeah. Okay.
If this is lacking a disclaimer that has been required by this board in previous action,
or has not been addressed at all. That's where I'm at, is at this point, we want, and it's been even the board in its entirety here, we want to make sure that we're following the rules. And if we haven't been doing that, let's make sure that we do it moving forward.
does this portion even apply to what we're doing here?
Well, I think, Member Bradshaw, I don't recall that we've had this particular question on a recall petition about the disclaimers. So we don't have any precedent for addressing that. I mean, that disclaimer portion is imposed by the Campaign Finance Act, which is solely interpreted by the Secretary of State. So it would really be the Secretary of State's determination when and if a disclaimer is needed. And the punishment for campaign finance violations is usually a fine. So sort of the remedies or what's required and what the remedies or the penalties are imposed for not having one appears over in the Campaign Finance Act, not necessarily here in the election law. So as far as who decides when, if a disclaimer is needed, that would be the Secretary of State. It's not really a form question for the board. I agree with Mr. Fracassi that the 961 section places the form question at the end of the process in front of the Secretary of State. So the proponents run the risk of circulating a form that's deficient and then finding that out at the end. But it's not a upfront process, it's an end process. As far as when a disclaimer is needed, I would defer to Adam on that, as he is our campaign finance expert.
So what Section 47 of the Campaign Finance Act requires is essentially that all printed matter that supports or opposes a candidate in an election, so in this case, like a recall would count, that all printed matter must provide a paid-for by statement that says paid for by whoever pays for it with the address. How we, in other contexts, in the Campaign Finance Act context, have interpreted that is, number one, if you're an individual acting alone, purely I am doing this on my own without coordinating with another person, without soliciting funds, anything like that, in order to further this, that you are an individual acting alone and the law exempts you from those requirements. Second, if you don't pay for, like if there's no cost associated, then there's no paid for by. I agree with Heather. I'm not sure that we do advise in the petition context, in the ballot question side of things, that you do have to have the paid for by on there. I'm not sure we've ever had the discussion about recall specifically.
I did look at the citation that Mr. Brewer included in his position letter, and the guidance under the Campaign Finance Act does say that there needs to be a disclaimer on recall petitions. That was something that I had never thought about before, and perhaps this board has not addressed that question before, or the question of when that disclaimer has to be put on the petition. So Mr. Brewer is raising unique questions that are unique to us at this point. But we certainly need to address them and decide, what we think is important to have on the petition. Do we have other questions of staff
Can I ask
or
one,
Mr.
Mr.
Brewer?
Brewer? Mr. Brewer, one of your points in your letter, and you've made the point here as well, is that these are really kind of ghost petitions being put forth by one individual. There's one actor here who's putting them out. Is that supposition, or is that?
That's our belief based on the evidence we've got so far. But the problem, Mr. Hauskamp, is the lack of a disclaimer, right? I mean, there's nothing on. But all we know from the correspondence with the Bureau is that this Frank Tarnowski, who is a resident of Wyandotte, is the alleged contact person for at least 4 of these petitions. So he links at least 4 of them together. And as I point out, the handwriting for the reasons on all 6 is virtually identical. So it seems pretty clear to us, based on the evidence we've seen, that one person wrote all 6 of these, and it wasn't these people who have allegedly listed their names as sponsors. And, they're not here, or at least they're not willing to come forward and explain the circumstances surrounding why their name ended up on a petition they did not draft, because the handwriting is very distinctly different. So my argument, my allegations to you and the board, Mr. Hauskamp, are based on the evidence we've seen so far.
Mr. Brewer, does the disclaimer has to say who is paying for the matter?
Correct.
But does the sponsor need to be the person who is paying for it?
No, it could be different persons. And I would respectfully disagree with Adam. I think an individual has to put a disclaimer on here as well. And it would be paid for by Mark Brewer with my address. I respectfully disagree with Mr. Fracassi on that. I think whoever is behind this petition needs to have the disclaimer on there. And again, the Bureau's guidance is very clear. Do ballot proposal petitions require the identifier? And I'm quoting from the Bureau's guidance. Yes, a ballot question petition and a recall petition must bear the identification statement.
Right.
And that's based on Section 247 of the Campaign Finance Act.
I think you've raised some valid points and questions, particularly the disclaimer issue. On that portion, though, of kind of is this ghost written, who's behind this? If the Michigan Democratic Party or Michigan Republican Party wanted to go after a handful of legislators on the opposite side, and they came up with the language and avoided the handwritten issue and had it typed, and then had voters in each of those areas, I don't think there would be a problem or a question of that, because hopefully they would be properly disclaimed on the bottom that that's who is paying for this. So I'm, I guess, disagreeing in some type with the issue of, because somebody else wrote this and came up with this, the voter in the area that the recall is to take place can't sign their name and be supportive of it.
Certainly, Mr. Todd, but those would be vastly different circumstances. What we're saying here, no disclaimer, handwriting on all 6 for reasons that matches, but does not match the people who allegedly signed as sponsors. So it's a combination of circumstances, Mr. Daunt, that I think provides ample grounds for this board to turn these petitions down and not even get to the issue of clarity. The situation you described, Mr. Daunt, if there was a proper disclaimer, and sure, there may have been people assisting and working behind the scenes to put together, very different situation. That's not what you have here.
Just for fun. Just for fun. Could we take up that issue of clarity?
Certainly, Mr. Hauskamp. Yeah, I addressed it. I'm trying to be a good lawyer. I have procedural arguments, but I also have substantive arguments. This petition is not clear based on this board's guidance, based on the case law, based on the statute. I think you've got ample grounds to reject this petition as unclear and tell these sponsors or whoever wrote this thing, these things, to give you a brief description and give the signers a brief description of what these bills are about.
I tend to agree with you on the clarity. This would be a difficult one for anybody to argue signing. But a question for the chair. It seems like Mr. Brewer's got a number of things here that we could climb this mountain on, right? I
That's
mean,
correct.
And some of those are things that are going to kind of put in stone a policy with this board. Is that also correct?
I'm not sure it would put in place a
Maybe-
policy,
okay,
but
maybe the
but
hard-
certainly
wrong word.
some
I don't think
precedent.
anything's in stone with us.
Nothing is ever in stone, but it would be precedent, and we would be, obviously, we're dealing here with the precedent from the Michigan Court of Appeals, and we also look at what the board has done in the past.
Let me cut to the chase. If we were to work backward and take up the issue of clarity, because these really do have a serious issue with clarity, that would be the issue that we would discuss and accept or reject, right? We could kind of step over all of the others?
I think we could decide
It has
based
to
on that
be-
issue without resolving the other issues that maybe Mr. Brewer is suggesting that we can't get to the issue of clarity and factuality until we resolve the others, but that's his position. It doesn't have to be ours. And we could, I think, address the issue of clarity, which is the simplest issue, in my opinion.
And that's clicking.
I've been back and forth. So, I mean, I am no handwriting expert, and this is not about that. What I find interesting, and I know having been here for a long time and having seen handwritten petitions for this, my issue is, and I've said that, how many times have I said this, that it's a legal document, please make sure you can read it. My problem at this point, and some of it, is clear penmanship, because I'm finding in the first one, I know that it's state representative, kind of, but you have S kind of scratched out. You have the next one where you have more kind of, if this is what they're bringing for us and just reasoning, they're not very legible, let alone I just have a House bill number. I was going to go for the fact that that when these are turned in, that the county is normally blank. But, that's just probably me being a little more picky. Because obviously some of these counties are multi-county jurisdictions. So.
And there would have to be a petition, as I understand it, with the heading for each jurisdiction within the county, right? Which is, a formidable requirement.
If we could, if through the chair, if I may, I think that it would be very important for Mr. Fracassi to go over the process of recall. Obviously, we have been here before for governors. We have been here before for state senators. But I think just understanding the process while we kind of look over and have kind of our internal conversations or here, but at least so that, obviously these hearings have been going on since I believe 2014.
13 in the current.
Yeah, in the current, since I've been here. Just again, to reiterate what this process really is. And then also, if in that process, could you let us know what the signatures are required if these were to be approved? Just so we can go over the process again, please.
Sure, and if there's something I leave out or that if I don't, let me know if I don't cover something. So the first step of the process is where we're at right now. So once the petition gets filed, the language is presented to the Board of State Canvassers to determine whether each reason stated in the heading of the petition is stated factually and clearly. Depending on board's action, whether the board approves it or rejects it, there are appellate rights, and that can, there's time associated, there's time restraints associated with each one of those. In general, the language, presuming it's approved, the language is valid for 180 days. If an appeal is taken, it's valid for up to 220 days. And the exception, though, is that if an appeal is taken, you cannot circulate. The statute prohibits the sponsor of the petition from circulating until the court makes a decision or 40 days has elapsed, whichever comes first. So from there, let's presume everything happens from there, it goes into circulation. The language, like I said, is good for 180 or up to 220, depending on kind of what happens. Signatures have to be gathered in a 60-day window. It's a rolling 60 days, meaning that our office will look back 60 days once filed. Anything beyond that 60 days is automatically invalid and will be rejected. The signature thresholds that have to be submitted depend on the office. Under Michigan's Constitution, it's 25% of the last vote for governor in the particular district. So it's every one that you have before you has a different signature threshold. So for the 20th district, these are all the minimums. So for the 20th State House district, it's 12,732. For the 27th, it's 10,875. For the 31st, and if I'm going too fast, somebody,
I'm not writing it down.
if anybody, I see some people writing, so.
Go for it.
So for the 31st, it is 10,747. For the 54th, it is 11,656. I'm going to skip back to the 48th because I just realized I went out of order. So for the 48th district, it's 13,232. For the 56th district, it is 11,113. For the 103rd, it is 14,053. And then for the 106th, it is 11,901.
What was the 20th again? I'm sorry.
The 20th is 12,732. And what is different with all petitions versus some of the other petitions that the board has seen, there's a couple of things different. Number one, the signatures are submitted with the Secretary of State for the Office of State Representative, and the sufficiency is actually determined by the filing official with recall, depending whether it's the county clerk or our office. So these will actually not be presented to the board if signatures come through again. We use the same standards that the board has opted with general petition review, so it's the same process that we go through. So that's the one difference. And the second difference is as you probably notice at the top of the petition, it is a city township form versus what you've seen in other candidate petitions as well as statewide drives. It's a county-wide, meaning that any jurisdiction in the county is fine, where a city, every single line has to be in the city and it has to be the jurisdiction of registration. So in the countywide, we would take Lansing, for example, as an acceptable for a mailing address. We do not take that if you're in Delta Township, for example. A Lansing mailing address is not sufficient. So there's a couple of differences with that. So I hope that answers your question.
Well, it was more of a clarification than a question.
Sorry.
Adam, just one, it's just a clarity question, because and I apologize because I'm repeating myself here, but this handwriting on this petition, for example, if this were to go forward and this petition were to be mass reproduced and people are out getting signatures, is it a requirement of this group or the law that it be exactly reproduced, in other words, the handwriting, or can someone take this approved form and then turn around and take it to a printer and say, typeset it? Are we approving the wording here, or are we approving the stroke on the letter O here in the handwriting?
That's a good question. So as far as the language itself goes, it has to be word for word what the board approves. If anything changes, it's invalid.
Not including spaces, but that's okay.
Correct.
Couldn't resist.
I whether or not, if someone were to take this and type it up and print out, as long as we would look at the language, we've never had that, so I don't know. We've actually only ever had one petition submitted under the new recall statute. So I'm not sure I know the answer to that question.
When you say submitted, are you referring to one where the signatures have been collected and it's
Correct.
filed with the Secretary of State?
That is correct, yes. We've had several submitted for the language, as we know, but we've only had, since the statute was amended in 2012, 13, we've only had one petition where signatures were submitted to our office.
So your explanation was really helpful for me, because what you have said and what 961 says is that we don't see the petition again. So if somebody if somebody collects signatures and submits it under 961, it's the Secretary of State who determines sufficiency, which we would do with regard to nominating and initiative petitions.
Correct.
So, do we have other questions for Mr. Brewer about the issue of clarity?
I don't know if it's necessarily a question. I might get to one as I ramble around. We've had recall petitions before us, and I remember that the discussion focused on there essentially being too much wording in there, too much opinion. And in my mind, just stating simply this individual voted for this bill, you've left all of that interpretive language out of there. You're simply stating they took this action on this bill, which was related to their duties. It's my understanding it's on the signer of petitions to know exactly what they're signing. And if somebody came to me and said, please sign this, Representative Church's vote on 4145, I'd say, well, what is 4145? I would expect them to give me an answer, hopefully truthful, but most likely, in fact, what I would do, well, first of all, I'd say, I'm not going to sign this because I'm on the Board of Canvassers, which is a fantastic way to get out of signing anything. But I would pull it up and look online to see what this bill did. And then if I agreed with their reasoning, then I would sign it. And if I didn't, I would not. Maybe the next cleanest would be, to utilize the summary in the bill or the title itself, but then you could get into a pretty lengthy run-on before you get to the meat of the issue. And I can see a lot of people who are simply trying to engage in their constitutional rights would seek to summarize it. They would, use the beginning, cut out the middle, and get to the meat of it. And I'm certain whether it's you or somebody else on any side of the aisle as an attorney would say, well, that's not sufficient enough. So I think each of you have maybe indicated a reason or a problem with the clarity. I think it's fine. I think it does exactly what you're looking for.
If I could, I think that the clarity actually picks up on Mr. Brewer's comment about somebody being able to change the handwriting, being able to change the meaning. If I've got, if someone's out there gathering signatures and they're looking for a signature because someone voted yes on House Bill 4474, in effect, to me, what that means is whoever's gathering that signature could tell you that House Bill 4474 is whatever they want to tell you. From a clarity standpoint,
That's correct in terms of what the circular could say, but that's why the statute says in the petition, to head off the problem that Mr. Daunt described, in the petition, don't misrepresent what the legislation says. And again, it's on page 3 of my letter. This board has set forth examples of approved language, and I think Mr. Daunt, again, look at page 3 of my letter, there's a description there of a recall against former Senator Meekhoff. It said he voted yay, it gave the number of the bills, and it gave a very short description of what the bills did, and this board approved that. And that's the standard that the board is demanding, I think, and should, of recall petitioners, reinforced by Donegan and not undermined by Whitmer.
Yeah. When I received the petitions from the Bureau and saw the language, voted yes on House Bill number 4474, whatever it was, my immediate thought was I need to know what that bill was. And I think that that's what anybody who is asked to sign the petition needs to know. And I looked, well, first at the statute, which says that we have to decide whether each reason is factual and of sufficient clarity, and that the reason cannot, if the reason is related to legislation, it must not misrepresent the content. That suggests to me, particularly the line about must not misrepresent the content, suggests that there should be some representation of the content, sort of a negative predicate. But I then looked back, particularly at the Donegan case, which was cited in the Whitmer case, Whitmer's the most recent case. The Donegan case is one which I actually lost at the Michigan Court of Appeals. And what it specifically said, and this was a lesser requirement because this was prior to the amendment of the recall statute. So at the time that Donegan was decided, they were only looking for clarity and not factuality and not considering whether it could be a misrepresentation. But the Donegan court said that the language was sufficiently clear because it identifies the House bills and indicates that one of the bills increases taxes and one imposes new taxes. So there was some, albeit short, but what the court said was a sufficient description of the content of the bills or the subject matter of the bills. I tested this on my husband and a couple of other folks. I said, look at it, says, voted yes on House Bill 4474. Do you think that's clear? It's clear, but it's not sufficiently clear because I don't know what House Bill 4474 is. I mean, that was my reaction, and I believe that Donegan, which, as I said, is cited in Whitmer, is the one that really should guide our consideration of what clarity, what the requirement of clarity requires.
Is it reasonable to assume that we could say it has to be clear enough for an average voter to at least understand what it is they're doing?
I believe the courts do refer to informing the voter. I believe that language is in Donegan. And I think certainly that is the intent of the statute. Here it is. In Donegan, and as I said, this was a lesser requirement. It was just clarity and not factuality and clarity. But what the court said is that what is required is that the reason be stated with sufficient clarity to enable the officer and electors to identify the transaction and know the charges made in connection therewith. And I think a focus on the voter is appropriate, and the whole issue about representation of the bill and misrepresentation is one that you identified. If it doesn't say House Bill 4474, which, on the red flag law, or I'm not sure if it is the red flag law, but then somebody being asked to sign the petition can be told anything.
But you just made an interesting point in what you said. You're not really sure what 4474 is.
If somebody, somebody says this is the red flag bill, the red flag law is their summary, we're going to get 6 attorneys up here arguing over whether or not it says that and where it says that. And that's why putting just the bill number on here is clear and concise, and people, you have a computer at your disposal. Look up what you're signing.
I remember having this conversation, I think via Zoom, when we were remote, on a number of these petitions that we had. I know. I know what House Bill 4474 is. I don't know which one is 4139, but the question is that these recall changes were made, and as a board, we have always been left to kind of interpret it. And when we have to adjust it due to court cases or anything else, we've done that. So that's kind of where as long as I've been on this board, I've just been more adaptive to making it simpler. And I see where Tony's point is, absolutely. But I also, it's also an assumption to be made that everyone has a cell phone and that everyone has, because most of us, when these are circulated, you are either coming out of somewhere and your hands are either full or your mind is not talking about these. And yes, saying that I'm on the board of canvassers is a great reason not to sign a recall or sign up any petitions. But for me, this is a legal document. I'd like to know exactly what's going on with it. So I'm kind of I'm in a point where I feel that maybe we need to start looking at other things that maybe weren't brought up before, but I'm also, I just feel they're going to keep coming every single time that there's a vote that someone may not approve of when there is an election process to take care of those means.
We've spent lots of time in the past on these, having those discussions and proponents and opponents doing what they're being asked to do, which is find reasons to encourage us to go with them or encourage us to go against it. And a lot of that on these recalls is focused on interpretation and, we know what the red flag law is, but does John Q. Public in Escanaba know what that is? And so the less that's on there that's open for interpretation, to me, makes the most sense. So
Maybe a little bit of a sidebar here is we're having these conversations and we're arguing back and forth as though we were the proponents and we were the defense. But I don't see any, is there anybody in this room at all who represents any of these petitions? Are you one of the sponsors?
the most sense. So
Maybe a little bit of a sidebar here is we're having these conversations and we're arguing back and forth as though we were the proponents and we were the defense. But I don't see any, is there anybody in this room at all who represents any of these petitions? Are you one of the sponsors, sir?
Yes, I am.
What is,
My name is Clicksby, and I'm the petitioner on the No Arbor petition. And I'd like to speak when you're ready.
You didn't find, oh, I see.
yeah.
Oh, okay. I'm sorry, you're Mr. Clicksby, did you say? Okay, I did not realize that we had additional speaker requests. So, Mr. Brewer, if you could.
My last comment is I would ask you to ask Mr. Clicksby why the handwriting on his petition, his signature and printed, is different from the stated reasons. It simply demonstrates the point I make here this morning. These petitions were written by somebody else, not by Mr. Clicksby and the other people whose names appear. Thank you very much. I'll be available for further questions.
Mr. Clicksby?
to thank you for the opportunity. There's a number of issues that
Okay,
you have
Mr.
talked
Clixby,
about.
Mr. Brewer was an attorney, and so we don't swear in attorneys, but would you raise your right hand? Okay, will you solemnly swear that that statement you are about to give is the truth, nothing but the truth?
Yes, I do.
Could you also spell your name for the,
Spell your name and address, spell your name for the court reporter, please.
My last name is spelled Clixby, and my first name is Gerald, Gerald. There's a number of issues that have been brought up that I'm not really qualified to speak for or against. I don't have a background in election law. I'm not an attorney. I'm not as smart as Mr. Brewer. I'm also not as creative as Mr. Brewer. I'm just a farm boy from the Midwest. I'm a citizen of Michigan all my life, and I'm very concerned. That's why I'm here. That's why my signature appears on that petition. The fact that it's two different handwritings is totally immaterial. The attorney, he stated that it's a ghost petition. That's his belief. That's his belief. It's not a ghost petition. I'm here today in front of you. That's my signature on my petition. I'm not a ghost. As far as a printed or typed in petition, this is your form. This is the form. You have a copy of it in front of you. If you will scroll down to the very last printed line at the bottom of that petition, it says Michigan Election Resources, form number 2011, 2015 revision, approved by State Director of Elections. This is your form. This form is formatted to fill in longhand. Take a good look at it. That's what this is for. It's to fill in by longhand. And that's what was done. So I don't buy the fact that because it was filled in longhand or even by two different people or two different handwriters that it's somehow illegitimate. We handwrite names on ballots. I mean, how can we disallow handwriting on petitions but allow it on ballots? The reason's not clear. The reason is very clear. It's very concise. I agree with Mr. Daunt here. And it's probably more accurate than some of the verbiage that has appeared on some of the proposals on the last ballot. This is very concise. It doesn't get lost in the weeds. It doesn't misrepresent anything. This is the reason. Noah Arbut voted yes on Michigan House Bill 4474. And it's the absolute truth. You can research it. It's valid. You know, if you talked about being concise, have you guys read any of the bills that our legislators vote on and pass? Talk about lost in the weeds. And I'm holding in my hand the bill, 4474. And I don't want to get lost in the weeds here, but this bill is not concise at all. It talks about perceived notions. It talks about people's feelings, how badly they've been intimidated. it talks about malicious. Well, if you look up malicious in the Webster's dictionary, it's defined also as mischievous. So if you're mischievous, you violate. You can't live one day of your life anymore without violating a law. And this is going to open up the door to legalizing the undue process of law. Will burden our court systems, will burden our police departments. This, when you talk about a mishmash, this is a mishmash. This is dangerous, and that's why I filed this. I would urge you to consider my recall petition. I can't speak on the others. I don't know them. I don't know what transpired there. But this, make no mistake, is my petition. I signed it. That's my signature. And as far as that topic goes, that's all that really matters. You can talk about all kinds of creative issues, but this is what it is. Thank you for listening.
Stay there, Mr. Clixby. Do we have questions for Mr. Clixby?
I just have a general question. And I think this goes to, and it's, I appreciate you being here today. And actually, this is one of the few that I actually can read. It's very clear. This one actually is handwriting. I actually can read on the top. It's not, you don't have any corrections like some of these other ones. I think it's more, it's not a question to you. It's actually a comment to my fellow board members. When we have House bills, and maybe this is to you as well, Mr. Clixby, would it be helpful to have the sponsor of those bills posted in the title? Do you know who the sponsor of this bill is, Mr. Clixby?
It's Mr. Arbit.
Thank you. I just want to make sure. I mean, I think that when we're looking for clarity, maybe, because Tony, I 100% believe you. We've sat in here and have had these conversations, but maybe that's something that's additional. So it's additional information. Because if someone said to you, no, that Noah Arbit voted yes on 4139. Do you know what House Bill 4139 is?
Not off the top of my head.
Do you know
but I
who
could find
sponsored?
out.
Right, but if someone came up to you at the grocery store, handed you this petition, because you're Noah's constituents, and said he voted on such and such bill. Now, how would you react? I'm just asking you as
I talk to a lot of people, and there's a lot of people very upset. They might not recognize it by number, but if you mention the hate crime bill, it's been on the news. A lot of people are very, very much in tune with what that is all about. They may not know all of the nuances associated with it, or what, and there's a lot of people very upset. They might not recognize it by number, but if you mention the hate crime bill, it's been on the news. A lot of people are very, very much in tune with what that is all about. They may not know all of the nuances associated with it, or how it can impact down the road, but everyone that I talk to has questioned that. Even people from out of state have called me up and said, "What's going on in Michigan?"
But you can understand why we're having the conversation here of like.
I do understand. I do
Yeah.
understand. I understand completely. And I guess my answer to you is that's why I kept it concise. I didn't want to get lost in the weeds. It's very easy in this day and age to get lost in the weeds. We live in a 24/7 news cycle. Everybody's got a take on everything. Everybody's spinning things. If we were gathering signatures, I would have a copy of the legislation. They can look at it themselves. I'll hand it out.
So the question I have, this is just this, because part of this process is, and with this petition submitted, hold on, let me just make sure that I have that correct. Let me get to that one, just give me 1 second. Adam, this one has the roll call sheet attached to it, or was there any other, there was nothing else attached to this? So the bill was not attached, and there was no roll call sheet. We have 7 of these, so let me just make sure I have the right thing. So I don't have any other documentation for this petition.
For this particular petition against Representative Arbit, correct? There's nothing else that was
There
submitted.
was nothing else submitted except the petition.
Correct.
Okay,
And then the response from Mr. Brewer.
okay. Some of these,
Do you have questions?
I'm good. I just wanted to see what additional information we had with this petition, but there was nothing else submitted in this that I have here, there's nothing else except for the petition. Okay.
Sir, you made a great point with the idea that this is you filling it out, coming in front of the state. It's your right to do. If this petition were granted and you were to go out and start to collect signatures, are you funding this recall? Is this you that's paying for the recall?
No, I'm not paying for the recall.
So
I think there's probably a lot of people that are chipping in here and there. I mean, this is pretty much an organic thing. If you're asking who's funding it, your guess is as good as mine. I mean, how much do you need to fund this? What do you think my budget is?
I guess that would be a question, but no, I'm not going to ask that question.
What kind of a budget would I need to file this? I file this, didn't cost me anything to file it.
Is there
Didn't cost
another
me anything to fill it out.
organization, is there another organization that is behind what you are submitting today who has given you a commitment that they would fund this petition?
No, but I can tell you this, there's a growing movement of people on both sides of the aisle that are very much in opposition of this House bill. I've talked to a lot of them, and a lot of them talk to each other. It's grassroots. It's totally grassroots. That's what a lot of people in Lansing don't understand. There is a movement out there. It's grassroots. It's not funded. There's no big budget. We don't have big donors that are lining up to throw money at an issue like this. Nobody wants to touch this. I debated whether or not I'd even come today. But I hear all of this mishmash, and I'm thinking, we got to cut through this. I mean, I'm listening to Mr. Brewer talk, and he's very creative. He's put every point out there that he could possibly make, and my hat's off to him. He does a great job with it. But I'm just a taxpayer. I'm just a citizen. I'm concerned. I have kids in this state. I've raised them here. I've lived here my whole life, and when I've gotten to the point where I'm at the point in my life where I say, if I don't like something, I better do something about it now.
Mr. Clixby, you said that you decided just to say that Noah Arbit voted yes on Michigan House Bill 4474. You decided what to put on the recall petition?
Yes, I did.
But somebody else wrote that. That's not your writing.
I thought it.
I'm sorry, what?
I was thinking it. I signed it.
No, I understand.
I'm here today to tell you that's my petition. I signed it. Is there anything else that matters?
Well,
What else matters on that to you?
what-
This handwriting discussion is starting to upset me, because if somebody printed it and typed it, how do we know who did that? Let's get beyond that. He has attested and put his name that he believes in this, and he is willing to put his name down and circulate it. I don't think somebody else writing it means shit.
The question.
Madam Chair,
Yeah.
I'm sorry, but may we take a recess? Sorry, I have to use the restroom. Thank you.
We will recess for 5 minutes. Be back at 11:15.
Mary Ellen need to be buttoned.
Oh, I'm sorry.
There you go.
Yeah, back on the record. I always forget. Does anyone have further questions for Mr. Clixby?
No, if I may, I just want to, I got a little heated there and dropped an S-bomb, so I apologize. It's for me, it's, Mr. Hauskamp brought up an issue jokingly, and I think it's funny, and the court has decided, but related to an issue from last go-round where an organization with tens of millions of dollars at its disposal related to a ballot initiative made a massive foul-up on the printing, and it ultimately moved forward through the court system. And I may disagree with that, but that's the court spoke and we move forward. We have just regular citizens like Mr. Clixby. Some of these people may have others behind them, but trying to bring up such, in my mind, ridiculous reasonings of it's handwritten, but then he signed it, that just really frustrating to see that. I understand that, Mr. Brewer, you have position to take. I don't begrudge you any of that. I just think I was getting tired of that conversation, and I'm glad we ended it, and I apologize for swearing. So I'll probably do it again at some point.
You probably will. Okay, we have one other person who has asked to speak. These came to me somewhat belatedly. And she has asked to speak as to agenda items number 7 and 10. The issues raised, at least with regard to 10, are the same as the issues that, these came to me somewhat belatedly. And she has asked to speak as to agenda items number 7 and 10. The issues raised, at least with regard to 10, are the same as the issues that, number 10 is a recall petition against Donnie Steele. Number 7 is the recall petition against Cameron Cavett. So similar issues are raised, at least as to 10, as to the issues raised with regard to the ones that Mr. Brewer and Mr. Clixby have been addressed. So I think it's sense to consider Ms. Edwards' position before we make further discussion. Yeah. Can you spell your name and a name for the record, please?
Michigan since 1999. I'm here to speak on behalf of agenda items 7 and 10 with regard to Representatives Cavett and Steele. I just wanted to encourage the board that to the extent you may agree with any of the arguments made by Mr. Brewer, to ask you to apply that same analysis to the remaining 2 petitions.
I'm sorry, would you say
Am I
that?
not loud enough? I'm sorry.
Yeah.
To the extent that the board agrees with any of the analysis or arguments made by Mr. Brewer, I would ask the board to apply that same analysis to the remaining 2 petitions brought against the Republican members of the House, Mr. Cavett and Ms. Steele, because I think many of the issues are the same. The handwriting, the ghostwriter, the bill number, which is the only reference in the petition against Representative Steele, lack of a disclaimer, who's funding it, the proponents not being here to make their case and to explain any of that to the board. I apologize if I'm looking at my phone. That's where I have my digital image of the petitions. But with regard to the Steele petition, it references only Michigan House Bill 4139. Doesn't have any further explanation as to what that bill is. It's a bill that addressed the Code of Criminal Procedure and the Michigan sentencing guidelines with regard to the larger context of firearms, but it doesn't say that on the petition. And with regard to Representative Cavett, slightly different, but I think perhaps even worse, it references roll call number 1, which would make even less sense to the average voter or the average person being asked to sign a petition. It does have a little bit of additional explanation, the question being on the election of a speaker. The petition alleges that Representative Cavett voted yes, doesn't say who he voted yes for. So I think there is also potentially a lack of clarity there as well. But the same issues about being just a number on a petition. What's roll call number 1? The average voter wouldn't know that any more than they'd know what House Bill 4139 might be. So I just wanted to ask the board to apply the same analysis to all the petitions as you're looking at the legal issues raised by Mr. Brewer. His always so inventive.
Thank you. Any questions for Ms. Edwards?
Just to confirm, you are the attorney of record for both of those
Yes, sir.
representatives?
Yes, sir. And although I just wanted to clarify, I am a state employee, but I'm here on my own personal time, taking a vacation day today. So I'm not here on state time. I'm here on my personal time. Thank you.
Do we have further questions either for staff or for each other or further things that we want to say?
Madam Chair, I think I have two questions that will help me with moving forward on these, and I think we should take them individually.
I think we need to take them individually. Yeah.
And it's probably for the staff, whether SOS or AG. Have we approved a recall petition as a board in the time I have been on here that was worded in essentially the same fashion as these are, that they, on this date, they voted on this bill? So that's the first. And then the second, have we approved anything that that did not have a disclaimer?
I can speak to the first one. I'm probably going to ask you to repeat the second one to make sure I heard it correctly. And I just did something. I don't know what I did. Sorry. So the first question was, has the board approved something similar language-wise with this? So the closest, there's two that came in calendar year 2020. So the first one that I would point to would be one submitted by Brenda LaChapelle against Governor Whitmer, and the reasons recall were stated as follows. So it's a Gretchen Whitmer signed Executive Order 2020-38, parentheses, COVID-19 on April 1st, 2020. The board approved that, that petition on July 31st of 2020. And then the second one that I would point to as maybe being similar, there was one submitted by Chad Bosse against Lieutenant Governor Gilchrist, The reasons stated as follows. It says, for signing House Bill 4044 into law on November 21st, 2019, while Governor Gretchen Whitmer was in Israel. That was approved as well. That case is actually what prompted the Whitmer case that has been talked about today. Those are probably the two most similar. And then
second part was related to the disclaimer.
Okay. And whether the board's rejected
Correct.
any.
Right.
I'm not aware of the board ever rejecting for that reason. I'm not aware of it actually even being presented to the board, to be fair, either.
Okay.
And I don't know if Heather and or Eric want to jump in with anything, if I said something wrong, or if there's anything else.
Just in regards to the Whitmer case, which is the one that dealt with the language about House Bill 4044 and Lieutenant Governor Gilchrist signing it while the governor was in Israel. The court in that decision, the Whitmer case, made a specific point, which I think is important for the board to know, and that is, it appears on page 422 of the opinion, and this is a direct quote, by adding MCL 168.951A to the Michigan election law, the legislature only minimally expanded the information requirements for recall petitions. MCL 168951A parentheses 1 parentheses C does not call on petitioners to describe the pertinent legislation or executive order in detail, and therefore occasions no revision of the rule that a petition need not fully explain the nature and effect of the matter at issue. And there it cites the Donegan opinion, 279 Mich. App at 84. And then it specifically goes on to say, the governor's insistence that more information is needed than a bare citation of the executive orders at issue implies a duty of elaboration that is without statutory foundation.
And from our perspective on the disclaimer issue, is it, I'm probably asking you to give me an interpretation here in front of everybody. Is it safer for us to say, no, go put a disclaimer on this, or you're fine the way you are? I mean, I've said this before in previous meetings, probably whatever we do, someone's going to sue us, so.
I think the question is that something, I think that kind of what Tony was, Adam was saying in the beginning, is that a front end thing for us? Or is that a back end item? Like, is that, because in my time here, and I have been here the entire time since the changes in recall, I don't ever recall the disclaimer coming up, but it's been a decade, so I'll leave it to the lead.
Well, again, I think we've all agreed that we haven't had the disclaimer issue come up that we can recall. So, again, it's not something imposed by the election law, right? It's over in the Campaign Finance Act. To the extent its presence on the petition can be considered a form question, I think that's a back-end question for the Secretary of State, who examines the form and passes on the form of the petition. She's also the interpreter of the Campaign Finance Act. So as far as the question of does it need to be on there, that would be a question for the Secretary of State to determine. So, but again, brand new questions, so that's my best advice on that. It's also, since it lives over in the Campaign Finance Act, the penalties for not having it on the petition would be under the Campaign Finance Act, and that's going to be paying a fine, most likely. Adam can jump in if I'm wrong. So there's nothing in the election law that says if you don't have it on there, the petition's defective or signature shouldn't be counted.
There is not.
There's not.
But a question in that same vein, and again, I'm having a hard time hearing your voice, so forgive me if no, you're okay. It's me, not you.
It's me too.
You too there. From a disclaimer standpoint, Mr. Klickse raised an interesting point. He's a simple citizen who filled out a form, and he put his name on here as the sponsor, in effect, of this petition. Doesn't he qualify as also being the disclaimer under what we're asking a disclaimer to be?
So, depends, of course. Where it comes into play, there's a couple of things. So like I mentioned, an individual acting alone is exempt from the disclaimer requirement under the Campaign Finance Act. But that individual has to be acting alone in the sense that they can't be soliciting or coordinating in any effort with another person. So if an individual has this petition, if they were to, you can get a copy of the petition from our office, from county clerks. If you were to get that petition, if you were to make a copy of it and circulate, you would be acting alone, and you may qualify in that instance for that exemption under Section 47. But the second that there's some sort of solicitation or coordination, then committee registration pieces come into play, disclosures then come into play, and all of the other elements of the Campaign Finance Act comes into play. So I don't know if that answers your question or not.
It does, and it brings up a second question, and that would be, Madam Chair, can we ask Mr. Glicksy to come back up for just?
Sure. Mr. Clixby?
And Mr. Klickse, you're still under oath, correct?
Yes.
So given what the folks from elections just said, let me re-ask you one more time, just one yes or no answer. Is this petition that you're putting up here, is it to be funded by an organization that you're aware of to implement gathering the signatures?
I don't know who's funding it.
There's
a lot of people.
No, that's not the answer, though. I mean, are you going to go back, if this petition were granted, are you then going to go back and do you have someone who's going to writing checks to print these and circulate these? Are you?
Well, we would have to raise. I mean, let's walk ourselves through the numbers then so that we have a realistic idea as to what is going on here. You know, you're talking about how you'd have to do something individually. Nobody does anything individually anymore. Come on. I'm not going to do this individually. I've got to get 12,000 signatures on here, 12,700, probably 14 to be sure. I'm not going to do that individually. Everybody knows that. I know it, you know it. What kind of a budget does it take? Again, I'm going to tell you that there is a real grassroots movement.
Is there an organization that you are aware of right now that's going to write the check to collect the signatures?
There are people, it's grassroots. Some are a little more organized than others. There's all kinds of groups out there, Republican groups, conservative groups, whatever. You've got the Michigan Conservative Union. You got Michigan Conservative Coalition. You got some Tea Party groups. You got them all over the state. They're active in southeastern Michigan, where I'm from. I know a lot of these people. These people are workers. These are not rich donors. I've made a few donations in the past. That's information is readily available. But there's a lot of people who, they're workers, and they're aggravated by what they see going on, and they were aggravated in particular by the hate crime bill, because it's so, it's totally undefined. We've taken a bill that we had in the past that I think was perfectly capable of safeguarding people's interests. And now we've defined it in a way that it can't be defined. It's based on what somebody perceives.
We share we share some of your feelings, but I still have the same question. It's not getting answered. In Oakland County, in District 20, do you now, or did you, when you put this together, have an arrangement with someone who is going to, as an organization, grassroots, individual, or otherwise, write checks to get these circulations? Yes, that's a yes or no question.
I have met with people.
Okay.
From the organizations that I've mentioned.
Can you identify that organization, or can you identify those people?
Huh?
Can you identify that organization?
I told you, there's all kinds of groups. I've mentioned three of them.
No, you said you met with an organization and you used the term singularly. You met with an organization and some people, is exactly what you said. Can you identify the organization?
I just told you. I mean, there's a lot of people there. I can't identify all the people, but...
You can identify the organization.
Yeah, but those people are not funding it. This is where you find the people that will sign these petitions. It's grassroots. There's no one or two or three organizations that somehow have stepped up and said, well, we're going to fund this. They don't have money. They have people. They have manpower. They have people that'll go out, knock on doors, and get signatures. That's what they do. That's what I said. You guys in Lansing don't understand what's happening. This is grassroots. People are not in this for the money. They don't have a lot of money. Will somebody maybe throw in $20 or $50? Probably somewhere along the way.
Mr. Clixey, I've been grassroots for 45 years. I'm very familiar with grassroots, okay? That's not the issue here. The issue is there an organization you have met with before putting this petition together that resulted in them saying...
There is no organization that I have met with that is putting this together.
Or funding it.
Or funding. How much do you think it's going to cost to do this?
A lot.
Well, we'll see.
I think that just goes to the question of the disclaimer and the sponsor of it. I accept you as a sponsor, and I accept you as not needing a disclaimer except I'm also listening to what elections is saying, and as soon as it crosses the line of, here's an organization that's been organized to do this, that would not be you.
I have told you that I have made donations in the past, and if I have to make a donation, nothing outrageous, for some printing or something, I would be prepared to step up and do that.
Madam Chair, may I ask a clarification to Adam at this point?
Yes.
Adam, can you explain, so I just, I'm listening, I just want to make sure that I'm all on the same page here. The individuals who submitted these petitions, such as Mr. Clarkson here, the moment, now I just sure, if he has volunteers that help him, is he now considered an organization? Like if he was to have his neighbors and his friends and family help him, is he still protected as an individual? Now, if he's meeting with other groups, I can understand the group, like an organization, but if it's just the individual and they have volunteers that help them, such as when you are running a truly grassroots, it's just from the ground, and you're not having other organizations come in and help you, but I'm just saying, where's that defining line at this point? Because remember House Camp, I think that's where you're trying to get to, right? Is like, where's this line, Adam, that an individual who's a petition for recall is no longer considered an individual because they are, and I'm probably going to, they are.
Coordinating.
Thank you. I knew it was rare. It was a C word.
How,
Would that also apply to the people who signed the petition then?
No, we're just talking about the petition. It's like, you submitted a petition. You are the sponsor of the petition. What is the line of who you are coordinating with, of whether or not you are no longer yourself or you are now an organization? That is what I'm asking.
Well, I'm sorry, I don't have an answer for you.
No, I'm not asking you. I'm asking Adam.
So how the department has interpreted that, like the coordination issue, and we do have an interpretive statement that talks about this, but forgive me, I don't remember the name of it off the top of my head. But what we have said is that when an individual, so like we've said with this individual acting alone, that you draft it, you circulate, for example, you're acting alone, but the second you start talking to a second person, so in your you said about like a neighbor helping, you're now coordinating with somebody at that point. You're no longer an individual acting alone, which then would mean that when you start spending money, that disclaimer would have to be on there. And when you solicit or spend more than 500, the committee requirements come into play, the reporting requirements come into play.
So I just wanted to make sure that I had that clarification, is that the moment that the gentleman talks to his neighbor, who's supporting it too, now there's coordination, and if it's more than the 500, now they have to make a committee.
I want to clarify one
Okay.
point just to
Yes,
make
please.
it clear. So yes, except that, so if you are just talking to your neighbor to say like, hey, sign this petition, that's separate.
Okay.
Where that coordination is, I'm talking to my neighbor to say, help me further this petition, help me oppose this petition, something like that.
Take these
this
petitions with you.
action
Okay.
To support or oppose this candidate or ballot question.
And can you give me financial backing?
Yes,
Okay.
correct.
Could I ask a question? Could I ask you just to repeat, what is the threshold in terms of dollars for?
So to register, the requirement to register a committee is $500. But the disclosure requirement, if you're not acting alone, there's no threshold on the disclaimer. That is, if you spend a penny, paid for by has to be on there. If you are not acting alone. That makes sense. Okay.
I would suggest, Mr. Clixby, that you get legal advice from an attorney rather than,
Rather than this crackerjack guy over here.
No, Mr. Fracassi is an excellent attorney, but his obligation is not to serve as an attorney for entities which are engaged in the political process.
Mr. Gillespie, I want you to know, I mean, what you represent and what you're doing, we love. I mean, you're exactly what we try to support. Or at least I can only speak for me. My hat's off to you. I totally get what you're doing.
Well, thank
The
you.
reason for asking a lot of the questions is because we have 6 petitions, all with identical wording, with the single exception of who it is that's being recalled. And so anytime, I mean, put yourself in my spot, right? Anytime you have 6 people from around the state who suddenly wake up in the middle of the night and they have exactly the same wording to put on the petition, either there's some force behind that, or otherwise, you know, it could be divine intervention, but
The force behind it is grassroots. It's phone
that's a
calls,
word,
text
though.
messages, people say, let's get together, we're going to talk about this. And I've met probably 3 different times with groups of people. Some of them I know, some of them I don't know. A lot of them I don't know. But they show up. And everybody's upset with different things. There's a lot of people who have their pet little peeves, and one of the ones that is common to a lot of people is this one, the 4474. Somebody puts a petition down. I was the most vocal about Mr. Arbit's proposal. I said, I'll sign it. I'm ready to sign it. If I was thinking about doing it, as a matter of fact, it was probably my idea.
so, but what you just said was somebody put a petition down and you were the most vocal and you were ready to sign it.
And I signed it.
That's okay. That still goes to some group that is promoting this petition.
It's a group that is undefined. I can't give you a name of a group. There is no name to a group. We're talking about a bunch of people who, a lot of them, they're connected. They're connected. There's a lot of grassroots people out there, and they're connected. A lot of these people, they belong to, 2 or 3 different groups of people, and there's a grapevine.
But there was a group that you met with who said, we need to do this petition, here's the wording on it, and you were the most vocal and you said, I'll take the responsibility, I'll do this petition. Who was that group?
There's no name to the group. There is no name to the group.
Which I
think,
sorry to interrupt, I certainly believe you. I don't think you're trying to avoid the question. This gets to my concern of the disclaimer and this is what happens. Sometimes people run afoul of the law unknowingly related to these issues because it is complicated and you can do things that you don't know might get you in trouble. And I'm all about people, whether I believe in their cause or not, exercising their rights, but laws do exist that require transparency and disclosure of who is funding, who is organizing. And I think for this to occur properly, knowing who that entity is or who that person is important. And that's the other issues that have been raised today. I think I'm dismissed, but this disclaimer, knowing who's behind these things, I think is important.
Because it can be multiple. You can have multiple groups come into one group to back an item. And so I think bringing up the disclaimer is very important. Because
There's no
but
1 or 2 or 3 groups.
This is why I had,
Coordinating this.
so this is why I had Mr. Fracassi explain that process, explain it, because I'm with Tony. The more people that exercise their rights, I'm 100%, I've said that so many times on this board. But sometimes individuals can go into situations where they have now put themselves in I don't want to say, my words are not coming out correctly, but you could be putting yourself into legal positions that you don't realize that you're walking into. Is that a correct, like?
Yes.
Okay. And so I think that all of us here are at the point that we can probably have the conversation of these recall petitions. Because I think at this point, I mean, that's where I'm at. I don't want to make, I would like to move to that part of the meeting, if we could.
Can I order a transcript on these hearings?
Yeah.
Of course.
I can?
Sure. It's a public hearing, right?
Pardon me?
I said it is a public hearing, and you are entitled to a record of the hearing. Perhaps it's time for somebody to make a motion. I would first like, though, to address.
I think we should let Mr. Clark speak.
Oh, yeah, I'm sorry, Mr. Clixby.
Thank you.
And perhaps Mr. Brewer has another.
You're welcome.
Oh, thank you for coming. On that question of clarity, and we've got a number of questions before us, and maybe it's a little hard to take them in a particular order, but on the question of clarity, well, Mr. Grill correctly said that the Whitmer case says that that legislation does not have to be described in detail. That in detail, that's the critical thing, as is the citation right after that statement, the citation to Donegan, because Donegan essentially says at least the minimal that is necessary and recognizes that the citation to the House bills with an indication of what they were about, increasing taxes or imposing new taxes. That was what made it sufficiently clear. And the court does not disagree. The Whitmer court does not disagree with the Donegan decision. And that's really significant. And without being too legalistic about this, if the Whitmer court disagreed with that statement in Donegan, they would have had to say so, and that would have required the Court of Appeals to engage in further examination of the issue, and they didn't. So it is my opinion that, and I respect Tony for saying, I respect that the position that the less detail, the better. I think that some detail is necessary and at least some reference, because we've been talking about some of these bills that are referenced in these recall petitions, and sometimes it was the red flag law and then it was the hate crimes bill. Mr. Clixby himself said that if he were asked to sign a petition that just had the number referenced, he wouldn't necessarily recognize the number. And that's for me, the whole issue. The number does not give somebody who is asked to sign a petition sufficient information to make an informed decision. So that is my position on clarity. On the disclaimer, that's a really interesting issue, and I'm not sure that it's for us. But I think the fact that it's been raised is something that we really need to think about.
And ultimately, my thinking on like the issue of disclaimer of whether or not it's even for us to determine, at some point it's going to be determined. And so any group that's bringing these types of things forward, and I think each of us has said this in some fashion previously, that's why it's important to seek at least some kind of legal representation or review of what you've done so that you're aware of the process and you don't spend time doing this and then having it rejected because you didn't know what you were doing. And, we're not here to give legal advice to people, but again, if you're going to do this, know exactly the process so that what you're doing is not a waste of your time.
Do we have any further discussion?
A question, are we discussing one petition here, or are we discussing, there are 6 petitions here with
We have to
precisely.
go through them in order.
We do, okay.
Although the decision that we make on the first will, I think, necessarily decide what we do on the second.
That's a question.
But since in each of them, except for the petition regarding number 7, Cameron Cavett.
7 and 10 are different, correct?
7 is,
10 is the same as the other ones.
I'm sorry, what?
10 is the same.
10 is the same. So that,
I think 7
Right.
is the only one that's,
7 is the only one that is different.
I think.
Not to be pedantic, I think 7 is different in the sense that it's related to a vote for speaker. The others are related to a vote on a specific piece of legislation.
Yes. With the identification of the bill number and nothing more.
10 is for Bill 4139, right?
Right, it's different, there are different
It's just
bill
a different
numbers
bill
on
number.
these, right.
Argument's the same, right? Argument's the same, bill number's different.
Argument is the same, the bill number is different, you've got it, yeah. Anything further?
Madam Chair, I just want to ask our legal counsel, so on this disclaimer, I'm so sorry. Obviously, you can't really give us any real advice or advisement of this. Or can you?
Are we talking about the disclaimer issue? Sorry. What is your question?
I mean, is it something that we should be, that we should be looking at as part of this conversation today, or is this something that, again, is towards the end of it, once it's turned in?
I think just based on the statute that says the form
And
is,
Heather, when you speak,
oh my God.
Sorry, Heather.
you have a smaller voice
I
than the
know.
rest of us.
So the best advice that I would have is, the statute specifically puts the form question to the Secretary of State at the end of the game. So it seems to me that that's where the question would come up, and it would be the Secretary's determination whether, it has to be on there, because as of today, we can't say one way or the other whether the disclaimer has to be on there, because there has to be some money spent. So at the time it gets filed, if it gets filed, then the Secretary would make a determination, I guess. And that's presuming it's a form question that has to be on there that impacts accepting the signatures or not, right? And it's not clear that it is. I mean, the remedy for not having on there may just be simply somebody filing a campaign finance complaint and not anything to do with whether the petition fails going forward. So those are, I think, undetermined questions, but I think what we can say today is it's not a question for the board, because it goes more.
So we're best to just ignore Mr. Brewer for the most part from earlier today.
Never tell you to ignore Mr. Brewer, who I respect, but just looking at the statute that says the secretary examines the form of the petition when it comes to her at the time of filing, that's the best advice I have today.
Can I give you just an observation? I'm not sure it's relevant or not, but it goes back to what we've been talking about with grassroots and individuals filing petitions and organizations, shadow organizations that aren't identified. I truly believe in grassroots. I don't know anybody else here how you feel. I truly believe in the grassroots and in the power of the individual to process a petition. But I also think that when grassroots come together in an organized, concerted fashion, whether a group is named or not named, someone brought those folks together, and there's the implication that there's a group the same way as if it was a large lobbying firm, or the same way if it was a large organization who said, let's go out and hire people. And so grassroots ceases to be grassroots by itself when it's driven by an organized group of people. Is that a fair way to state that?
I wouldn't say it ceases to be grassroots. I'd say it begins to accumulate obligations to the law.
There you go.
Okay. Perfect way to put it.
Yeah.
Would you? Go ahead.
Mr. Clixby, do you, one further.
In order to have an organization, you have to have a spokesperson. I guess I'm the spokesperson at this point. Not that I wanted to be, I didn't start out this way.
No, what's dangerous to democracy is that you don't have to be a spokesperson, or have a spokesperson, and that's part of what we're watching happen in our society, in my opinion, is we have a lot of people who want to be grassroots, but the truth of it is that there's organizations that don't necessarily want to be identified coming together. And so you as the spokesperson, as the sponsor for one petition, I totally get your story. I totally agree with you, but I have this one small problem. There's 5 other petitions here with precisely the same wording. And so it's still grassroots, but now all of a sudden it's organized grassroots. Now you're a little bit more akin to, I got to be careful how I say this. Now you're a little more akin to somebody who's buying a franchise. Now you're a little more akin to a direct distributor for someone else. And so you're still grassroots, but there's a different level of organization. Do you understand where I'm coming from?
No, I understand what you're saying. It's hard for me to respond to that.
I'm not sure that you really need to, Mr. Clixby. I think that we have explored this issue. And we really, it has been very helpful for us to have you come and address us. You are the only petition sponsor who is here today, and we really appreciate it. And it's been, as I said, it's been helpful for us.
Thank you for listening.
Are we prepared? If no one has anything further to add, I am ready to make a motion. And that is as to item number 3, the petition seeking the recall of State Representative Jamie Churches, House District number 27. I move that the Board of State Canvassers determine that the reason for recall printed on the petition submitted by Sebastian Palomara against Jamie Churches on July 12, 2023 is not, is not sufficiently clear because the reference to the bill number only does not give enough information.
I'm going to second that.
Discussion?
My reason is, it's not, my reason, I'm sorry. Yeah, I'm sorry. I'm normally I'm the one who hits the button. I found that it's ineligible handwriting. I'm sorry.
Say it again.
Ineligible handwriting. You have corrections on
Illegible.
here. Yeah. Illegible. And I said this when we were having these conversations. If you're going to submit something to the state, it should be legible. And there should not be any kind of corrections on here. And that is one of my additional issues with these petitions. And having seen the other ones from a long time ago in 2013, yeah. I mean,
Okay, so you have a different reason. So,
I know Mr. Don would like to speak.
I'm going to really complicate things. I have issues with the disclaimer, but we have been instructed that it's best that that's at the end. So I'm setting that aside. I believe that it is sufficiently clear. So I'm going to vote no on this motion. And I think that's all I need to say. I'm going to vote no on
I don't
this.
think you complicated it.
Yeah,
It's just discussion.
Right. Yeah, we haven't called for a vote yet, but we have a motion and a second.
I'm just telling you that personally, like, handwriting is going to be an issue for me, but I'll wait till the vote.
Okay, so it has been moved and seconded that the reason for recall is not sufficiently clear. All in favor of the motion? Aye. All opposed?
Aye.
Aye.
Okay, you're saying aye, but you mean nay. But,
I'm sorry. Nay.
okay,
Aye.
so,
Nay to the opposed.
yeah.
Like, wait, no, aye to the nay, yeah.
okay, so the motion.
We're two noes, and I believe we're two yeses.
Two noes and two noes. So the reason, and it takes 3 votes to determine that there is sufficient clarity to approve the petition. So the petition has not been approved. Am I correct in saying that, Mr. Fracassi? Okay. Member Bradshaw, did you want to make a statement for the record about your determination with regard to agenda item 3?
No, Madam Chair, I said it during discussion.
Okay, we will move on to agenda item number 4. The petition seeking the recall of State Representative Betsy Coffia, House District Number 103, submitted by Barbara Willing. This petition is identical to the petition which we just considered, except that it references House Bill number 4145 rather than House Bill 4474. Do we have a motion? I'll make a motion. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Barbara Willing against Betsy Coffia on July 12, 2023, are not sufficiently clear because the reference only to the House bill without further information does not provide the necessary information.
I'll second it.
Okay. It has been moved and seconded. All in favor? Aye.
Aye.
No.
I'm a no, but again, handwriting. Sorry, this one is a little bit worse than the other one.
Okay. So the board does not approve which submitted in the recall petition against Betsy Coffia.
Madam Chair, just for, as we see where this is going, I'm not going to make any motions, so it's up to you all to figure it out.
We kind of.
Okay, we've got it down. Okay, agenda item number 5, petition seeking the recall of State Representative Jennifer Conlon, House District 48, sponsored by Linda Ensley. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Linda Ensley against Jennifer Conlon on July 12, 2023, are not sufficiently clear because the reference to the bill number alone does not provide adequate information.
I'll second it.
All in favor? Aye. Opposed?
No.
with a note of handwriting, once again.
Okay, agenda item number 6, petition seeking the recall of State Representative Reggie Miller, submitted by Holly Evelade. I move that the Board of State Canvassers determine that the reason for recall printed on the petition submitted by Holly Evelade against Reggie Miller on July 12, 2023, is not sufficiently clear because reference to the bill number alone does not provide adequate information.
I'll second it.
All in favor? Aye. Opposed?
No.
No.
Okay.
Number 7 is separate. Number 7 is by
Number
itself.
7 is different. Okay, so we're going to take number 7 later. We will address agenda item number 8, petition seeking the recall of State Representative Sharon McDonald, House District 56. I move that the Board of State Canvassers determine that the reason for recall printed on the petition submitted by Michael T. Ross against Sharon McDonald on July 14, 2023, is not sufficiently clear because reference to the bill alone does not provide adequate information.
I'll second.
All in favor? Aye. Opposed?
No.
Okay, agenda item number 9, petition seeking the recall of State Representative Noah Arbit, House District Number 20, submitted by Gerald Clixby. I move that the Board of State Canvassers determine that the reason for recall printed on the petition submitted by Gerald Clixby against Noah Arbit on July 20th, 2023 is not sufficiently clear because reference to the bill alone does not provide adequate information.
I'll second.
All in favor? Aye. Opposed?
No.
No.
So the motion does not carry. So agenda item number 10, petition seeking the recall of State Representative Donnie Steele, House District 54. I move that the Board of State Canvassers determine that the reason for recall printed on the petition submitted by Jerome Allen against Donnie Steele on July 21st, 2023 is not sufficiently clear because reference to the bill number alone does not provide adequate information.
I'll second.
All in favor?
Aye.
Aye. Opposed?
No.
No, with a handwriting, please. There's a correction on, should have been corrected before it was submitted.
Good luck to the media trying to write all this up.
And your handwriting will be examined.
And as noted, it takes a vote of 3 of the canvassers in order to determine that the recall reason is sufficiently clear. So now let us have a discussion on agenda item number 7, petition seeking the recall of State Representative Cameron Cavett, House District 106. The petition differs from the others that we have considered. Do we have discussion? The petition says, on January 11th, 2023, State Representative Cameron Cavett voted yes on roll call number 1, the question being on the election of a speaker.
I take it back. I will make a motion.
I'm sorry?
I take it back. I will make a motion here.
Okay.
Again, setting aside the disclaimer issue. This, to me, is certainly clear like the others were. I have not had an issue with the handwriting, so I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Gary Nuck against Cameron Cavett on July 13, 2023 are factual and sufficiently clear because information stated meets the requirements.
I'll support.
Any discussion?
The handwriting was better. I mean, it honestly, it's written out more than roll call number one. There actually is a little more description to what is happening. Or happened, sorry.
Okay. All in favor?
Aye.
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 Okay, motion carries. The next item on the agenda is number 11, any other business?
Madam Chair, if I may ask our representatives over here, are any legal updates?
So the fracking case is still open and pending. We have no news to discuss on that case, but it is still a pending case involving the board.
I'm sorry, which one?
That was Graziano case, which was brought by signers of the petition to ban fracking in Michigan, challenging the constitutionality of the statutes and the board.
And how about Ickes versus Benson?
Which one?
Ickes.
Oh, we have not heard anything from the Western District yet either.
I had a question about the, how long have we had the legal conversation about,
Fracking?
yes,
A long, long time. No, it goes further back. If
Yeah.
you go back to the first controversy, I could find out, I want to, it's at least 2015, but I think it might actually predate that to 2014.
I was thinking, because and that's when they first came in front. I was just curious.
Various iterations, obviously this particular lawsuit was filed later and subsequent to a lot of the other decisions, but that particular petition is an old one.
The other question I have is just a general question. The work group that was brought together, because it did miss the meeting last month, what is the status of that?
Okay, the work group got really useful suggestions from practitioners who met with us, and we are hoping, and I need to discuss this with Mr. Fracassi, Member Hauskamp and I are hoping to get some further input from about the use of technology and where we stand, where practitioners stand, because I think we understood that the attorneys are not necessarily the ones who are most conversant with the work that is being done with regard to examination of petitions. They have people who work for them who they have agreed to make available to us because technology advances in technology, we are hoping will make our petition review process more expeditious. And we are also, and will be, I believe, making at our late August meeting some recommendations about whether changes in legislation would also make our review process better and easier and clearer. Because I think we know that Director Brader is anxious to have a revised manual out sometime late in the, or early, I said late in the fall. He wants it early in the fall. So, in addition, I did raise a question last meeting about whether it would be helpful to get some academic input with regard to the Raymond report. And I did request that from Wayne University, and the director of the Department of Sociology reviewed the Raymond report and made some comments about it, which I think are very helpful. Generally saying that the methodology appeared to be really sound, and so we're proceeding there as well. So that is it. Anything further, members? Okay. Meeting is adjourned.